So first thing to understand is, you know, right now he's facing up to 20 years right now in August. And just to take you through what happened, on April 8th, he was convicted. He was convicted on attempted manslaughter based on extreme mental or emotional disturbance, otherwise known as EMED. Now, as I mentioned to you, what the first thing you've got to understand is EMED, extreme emotional disturbance, is a mitigator. What's mitigator mean? What does that mean? Mitigation means it essentially lessens the punishment. Okay, it says, yeah, he did this, but there's a legally recognized reason why this should be looked at as less than if he just did it without this being present. The issue is that you must, in order to in order for a mitigator to take effect, they had to find that he actually intended to kill to kill his wife. That meaning when he went in that day, he was intending to do this, and then the EMAD is when he was making that determination of intent, he had extreme mental or emotional disturbance. In this case, the jury's pointing towards the affair and all of that stuff, and that factored in that this wasn't just a clean, I'm going to go kill somebody. He was very upset. He was emotional. He was mentally disturbed, but he wasn't mentally disturbed to the point where it's, temporary insanity. But it's just that there was somewhat of a reasonable understanding of why someone could get that angry, but they're saying he still formulated the intent and said, I want her dead. And that's what that takes. Anything else, recklessness or saying, hey, he gets into it and they get into a scuffle and he ends up doing something inherently dangerous, which could lead to a reckless, if she would have passed, if she would have died, that could have been potentially the foundation for reckless manslaughter. The problem is there is no such thing as reckless manslaughter recognized under Hawaii law, because they say you can't have intent and you can't be reckless at the same time. Therefore, the reckless manslaughter is covered under the assault charges or the attempted assault charges. That's where that lives. So this lays out the anomaly here was no one requested this. The judge added this in. The defense fought to keep it out. The state attacked it in closing, and it ended up ultimately being included as part of an option for the jury. The defense, for exactly the reason this is happening right now, the defense wanted it out of there because it was just going to cause problems and cause a potential misunderstanding of how to apply the law. That's exactly what happened. So the stakes here are, right now, he's facing up to 20 years. It is a probationable offense, although it's unlikely that he'll probably get probation, but it is a probationable offense. And, what's happened is on the 15th of, which is yesterday, on the 15th of May, the defense filed an 11-page motion alleging that there are fatal irregularities and outside influence in the jury's verdict. And that is important. The outside influence is something that we're going to talk about because it's kind of, serendipitous almost that the week that the Murdoch case gets returned or overturned for outside influence, this case, a motion lands in this case for outside influence. Unbelievable coincidence, I guess, in a way, but if that should tell you anything, it's something that judges, appellate courts take very serious. If anytime outside influence can be shown, and just like in the Murdoch case, what you're going to see the evidence being in this case, it's pretty strong that outside influence entered that jury room. So 3 triggers right now. The motion gives Judge Wong 3 independent legal paths to invalidate the verdict. Grounds 1 is misunderstanding instructions. Grounds 2 is a legally non-existent offense, as in the reckless manslaughter does not exist or attempted manslaughter does not exist anywhere in the Hawaii Criminal Code. And ground 3, outside influence. The brilliance of the way Otake constructed this motion is whatever door you walk through, double jeopardy applies and eliminates the top charge of attempted a second-degree unaliving. So basically any of those 3 grounds, and the third one is probably the one that's the most likely that the judge would walk through that door because it doesn't involve having to invade the province of the jury's decision making. So it's likely grounds 3 would be one that the judge could say, well, grounds 1 and 2, I'm not going to grant. We're not even going to enter there. You know, the jury, maybe they didn't understand things, but they were making a compromise. We're going to stay out of that. But if he finds on grounds 3, it's still going to cause, and we're going to go over that in greater detail, it's still going to cause us to not be able to go back and retry him on the top level offense. Now, the law governing navigating the strict boundaries of Hawaii's of rules of evidence is 606, HRE 606. And this is what's going to be at stake here for issues 1 and 2. And what it holds is it says that subjective mental processes, meaning, are off limits. And what does that mean? It means a judge cannot crack open deliberations to ask why a juror felt a certain way or second guess their internal emotions, meaning we are not going to go put 12 jurors on the witness stand after a verdict and say, wait a minute, tell us what your thought process was. Why did you do this? We might think they got it wrong, but you're not going to cross-examine a juror on what exactly occurred in internal debates, internal thoughts, emotions, all of that stuff. Now, what is fair game under Rule of Evidence 606, HRE 606, is objective misconduct and outside influence. And the precedents for this is Holborn and Furutani. Those two cases, which the defense cited, allows courts to examine objective irregularities, public statements, and improper external influence that could taint the deliberative process. And what they're saying is that's present in all 3 of those issues that they are raising. And these came up because of, well, one of them being because it was present in a live stream chat. The second thing that came up is the juror itself out speaking to the press on their own volition, discussing things that happened, discussing thought processes that occurred, and this was not done with inquiry from the judicial or from the judiciary. This was their own sharing, and what they shared indicates that there may have been that there was a misunderstanding of the law and a misapplication of the law, and therefore the defense is saying it's fair game. So ground 1, let's take a look at what ground 1 says, right? It's ground 1 is essentially it ignored the decision tree. It ignored the instructions that the judge gave this jury. And what the judge told the jury, and I'm going to get out of the way of this second one here. What the judge told this jury is the following, is that first you have to determine, did the defendant intend to kill? Before you can, EMED is not considered as it is not a place that you compromise at, okay? Not when you're determining the issue of intent or non-intent. Now, they could have dropped down to assault 1 to do that. That would have been perfectly fine. But you can't find someone guilty of attempted EMED manslaughter and then say, well, I didn't think they had intent to kill. It's impossible to do that. And the jurors failed to understand that. What the law says is did the defendant intend to kill? And and then if they did, was EMED present? In other words, was the intent to kill formed under extreme emotional disturbance or stress? And if it was, then you could find him guilty of EMED manslaughter. If you don't believe intent, which is exactly what that juror said to the press, as you're going to learn, then you must skip EMED and proceed to assault. And you go directly to assault, and you leave the attempted unaliving and attempted red rum, and you go directly to assault. Now, how do they know this happened? And this is important because the judge is going to say, okay, well, you can't just say that. You've got to know. Well, the way they know it is because these jurors, there were 2 jurors talking, juror number 3 and the foreperson. The foreperson said the intent to kill is improbable to us based on the evidence presented. She's speaking for everyone. Juror number 3 says, I don't know if he was trying to kill his wife. His conduct had the capacity to kill. Both of those are speaking to basically what would be considered to be and what would fall under the province of reckless manslaughter, but reckless manslaughter requires someone to have actually passed on. Since nobody passed on in this case, you look next towards the assault bucket. The assault bucket, yes, you could fit these squarely in the assault bucket and determining, okay, what level of attempted assault is he found guilty of? The jury didn't understand this. A conviction requiring intent to kill cannot stand when the foreperson swears they found no such intent. And she did that. And she didn't just leave it at a media statement. She actually swore to a sworn written statement that Otake is providing the court. Now, ground two, a legal impossibility. So the attempt equals specific intent aiming at a specific result. Hawaii law does not recognize the offense of attempted reckless manslaughter. The mental states cancel that out. In State versus Stanley, in State versus Loa, which these have been in law in Hawaii for several decades now, they essentially assert that you cannot intentionally aim to cause death while merely disregarding risk. Meaning you can't formulate intent while being reckless. If you're saying somebody was reckless, in other words, and that's what this jury was saying, that they end up in a situation where they end up in a mutual combatant situation, and then he ends up escalating to a point where that's reckless, that was so reckless it could have caused death or grievous injury, and as a result, that's what happens. She gets grievously injured. She gets her head cut open. That's far different. That's far different than attempted second degree red rum. Okay, which requires them to find that, yeah, he set out that day, or they could even find that, which is what the state was asking, which was a place the jury could have gone and said, well, when he was making this plan, he was deciding to do this, he was emotionally and mentally disturbed because of the affair. But that's not what the jury said happened. They don't believe he went that day trying to kill her. They're saying, we don't believe that. What we do believe is that there's a fight that happens, they get into an argument, a scuffle occurs, and then he does something reckless, and it results in an injury. That is assault, okay? No two ways around it. That's assault. And what they did is they created a separate crime that doesn't exist, which is where grounds 2 kicks in. And here's the 3 buckets for you to visually see. So first of all, you have attempted red rum. What does that require? Mental state is intent to kill. Conduct, tried and failed, they didn't get it. Exposure, mandatory 20 years up to life in prison. Now, what they did find is attempted EMED. It requires the intent to kill, and then they find that it wasn't just that he intended to kill. There was emotional disturbance in that equation. They found him guilty of this. You get probation to 20 years is the mitigation for having the emotional disturbance. The problem is that the jurors are saying there was no intent to kill. So if you subtract the intent to kill, now you're at worst, assault in the first degree, which requires recklessness and a disregard for risk. The conduct is dangerous act causing serious injury, which is, again, once you get into that mental state, now you look at what the level of injury it caused, and there's an additional case, which is why, again, the whole defense, the whole way all of this would have been conducted in the next trial will be totally different. But the exposure is really key. 10 years maximum, and you can definitely get probation for an attempted assault in the first degree. So, convicting in bucket 2, reasoning in bucket 3. That's essentially what I've just been breaking out for you here. Is the mismatch. Attempted EMED, but the reality is, again, based on what the jury is saying, is capacity to kill, could result in injury, emotionally unstable, all of that falls under the reckless disregard for risk. This describes, and again, State v. Stanley states that a conviction cannot stand when the jury's reasoning reflects a non-existent offense.